always, and this is invariably the trend, okay, they have always been claimed in context of injury and not harm. And the case of C. Venkatachalam versus Union of India, the Supreme Court also said that the principle of strict liability and negligence is the basis of product liability. Now this case was before the Consumer Protection Act 2019 came into being, right? So they essentially said that, listen, product liability is not a concept under this existing 1986 Act. But the principles of tort law, negligence and strict liability are the basis of your product liability action. So strict liability essentially qualifies any act toward illegality, read with the principle of statutory illegality. So these two facts are an authoritative pronouncement that yes, for all practical purposes, any damage is injury only and not harm, even under the present act, right? And there was also this very famous case, all of you must have heard this, McPherson v. Buick Motor Company of the New York. It was a 1916 case where it's celebrated the conquest of tort over contract. And it was said that, the premise of product liability is injury, and all claims under this doctrine must be referring to the same. So essentially my concluding argument would be that the legislature would have done an immense service to the legal fraternity, law students, and the courts as well, to include injury and not harm under the product liability regime, because for all practical purposes, the conduit for product liability actions is Section 84 itself. That's like the magnum opus of the Act, right? So any complaint, any consumer grievance is redressed through this particular series of sections. So it is seminal as to how we interpret the doctrine of harm and injury and how we dichotomize the difference in the same. I am optimistic that the courts would interpret future consumer claims, the consumer commissions would do so by interpreting harm as amounting to injury. Now there can be an amendment as well, and I would encourage the amendment to happen. But in case it doesn't happen, I think the commissions are guided by their legal wisdom to interpret harm as amounting to injury. So this would also preclude all frivolous litigations, because there is a big debate in academic circles as to the practical implications of this difference, and to essentially uphold the mandate of a social welfare beneficial legislation. I think this paper does a significant stride in the academic scholarship insofar as the reconciling of this particular difference, and this would, I believe, have a significant impact in consumer claims in the future as well. So I'd like to conclude my argument now, and if any questions, I'd be happy to address so. And thank you for giving me a patient hearing and audience.
Thank you, Mother. We'll take questions at the end of the discussion, at the end of the session. May I now call upon Tarun?
Greetings to all present here. I'm Tarun from first year LLB and LSIO. I'm here to present my arguments on the topic: consumer rights awareness in India in the digital era. Dear friends, we all know that today our world is moving towards a digital stage. Post-pandemic, everything has become digital in this country. And it is very much important for us to ensure that the digital era is not an era of victimizing the poor consumers in this country and making them a person who can be exploited by the MNCs or anyone of that sort. I'd like to start my arguments by quoting Justice Y.V. Chandrachud, who rightly said, the interest of the consumer has to be kept in the forefront. And the prime consideration that essential commodity ought to be made available to the common man at the fair price must rank in priority over every other consideration. Consumer is the king of the market. Understanding this, we had enacted the CPA, the COPRA in 1986 and the CPA in 2019. My paper firstly speaks about the consumer rights and the positions of consumer rights in India in the digital era. Secondly, it addresses the necessity for consumer awareness in India. Thirdly, it discusses the problems in creating awareness about consumer rights in India. Fourthly, it says the steps taken by the government of India to create consumer rights awareness. And lastly, I put forth my humble suggestions and recommendations to create awareness about the consumer rights in this country. So first, what are the consumer rights that are there? So the consumer rights history goes back to JFK's speech, in which he had identified 4 types of consumer rights and current consumer rights in the CPA. Earlier in 1986 Act, it was not established as a consumer right alone. It was there under this special statutory bodies that were established. But the drafters of this legislation felt the need for us to define what are consumer rights, and thus under section 2, subsection 9, the consumer right, they have identified 6 types of consumer rights. And one such right is right to consumer awareness, and my project focuses on that. Moving ahead, why should we create consumer awareness in this country? Dear friends, you have to understand that India is the 8th largest market when it comes to e-commerce, with 50 billion turnover that we have registered in the year of 2021 despite a pandemic. We are moving ahead in this space, and India for sure is going to be the leader of this field. When we are moving in this space, we need to protect the interest of our consumers, especially the interest of the Indian consumers, so that we can ensure an achievable target of 1 trillion by 2030, which the Commerce Ministry has set for this e-commerce industry. But the issues when it comes, the CULT survey that happened in 2012 rightly identified the issues that we are facing when it comes to consumer awareness in this country. The CULT survey said that only 42% of Indians have heard about consumer rights, and only 20% of the citizens know about the Principal Act. Now that's a very pathetic situation. And to address these things, to address these issues, we had a lot of steps taken by the government, which I'll be discussing in the later part. But why are we having this problem in this country? I divide these problems into 2 aspects: structural issues of India and non-structural issues of India. When it comes to structural issues, first is illiteracy, poverty-induced ignorance, lack of infrastructure. The UNESCO report in 2017 said that 35% of illiterate people are residing in India. With such high illiteracy rate, it is very difficult for us to create consumer awareness, especially in the digital era. Moreover, a lot of our, the digital campaigns or your websites are not available in all regional languages. We are a country of diversity. We have 22 official languages in this country, but you would hardly find 10 to 12 languages available in certain established, intermediary firms, and more of them even they restrict to 3 or 4. Given that thing, how are we going to advocate to our consumers what are their rights? They have, going with a shrink wrap, click wrap and other things, these consumers are not even aware what are they even doing. And the companies are taking advantage of this deplorable, this vulnerable situations of our Indian consumers. Moving ahead, the behavioral aspect of our consumers. Those consumers who are poor, for them the prime need is, I need to get this product at this rate. They are not concerned about looking into the other details, what are the liability clauses that are affiliated, reading the entire terms and conditions, they go ahead with it. That's the major drawback that we face, and CULT survey did identify this. Moving ahead with the non-structural problem, one is the budgetary allocation have reduced, considering that we had a pandemic and we had to prioritize other things. We agree that the government did cut some funds, but I hope in future it will increase with organizations like Kepler and others pushing forward for such wonderful needs. We ensure that the budgetary allocation will also increase, and moreover, lack of interest among the consumers themselves to make them aware of these laws. Nobody in this current country is damn interested in looking what the Consumer Affairs Ministry has released the press releases, what the document says, what are the rules, what are the regulations. We have to inculcate this habit of reading it. Why? The main reason is we all are consumers. Primarily, we all are consumers. We consume things every day, and in the digital era, we continue to consume, and our data is the biggest consumption of that the consumers face, and we'll have to be aware of the rights. The steps taken by the Indian government. The Indian government has always been vigilant in increasing consumer awareness. The 10th and the 11th 5-year plan had some special considerations on this consumer awareness programs, the Jago campaign maybe, or the press information bureau's press releases, Bureau of Indian Standard, which had initiated a mobile care app, or even the establishment of Ccpa, whose one of the objective is to spread consumer education. And as Sir was also explaining us the importance of Ccpa earlier, Ccpa was a novel thought that was brought here to not only regulate the market, but also to spread the consumer awareness among the poor Indians. And moving ahead, the suggestions that I put forth both long-term and short-term suggestions. In my opinion, we should start consumer awareness program at an early age in all schools and colleges. How important is to know A plus B the whole square formula? How important is it to know trigonometry? We'll have to know consumer rights, because though we may not use trigonometry in our life, we all are consumers and we are exercising these aspects of consumers in our day-to-day life. So therefore, knowing that is very much necessary. So I propose the recommendation. I recommend the government to include consumer education as a part of school curriculum. 1. 2. Schools and colleges should celebrate National Consumer Rights Days and hold large seminars like this in order to increase the consumer awareness among the masses. 3. We need to take the help of the neighborhood societies and start consumer awareness programs. 4. We need to take the help of the Taluk and Gram Panchayat in the active participation of creating awareness about consumer rights. The 114th Law Commission report said that the Panchayati Raj play a vital role in the promotion and implementation of the government policies, and the same should be incorporated in promotion of consumer education too. And finally, as the Cut survey rightly said, 40% of the population prefer TV advertisements as the best means of promoting consumer rights. So we need to take large-scale TV advertisements to promote consumer awareness in this country. And also finally, we'll have to ensure that the fallback liability is also advocated among the consumers, so that the poor consumer is not forced to run behind the manufacturer, but he can also get the intermediaries accountable for the negligence or for any other misfeasance, malfeasance of their act. By saying this, I would like to end my words quoting Mahatma Gandhi. A consumer is the most important visitor of our premise. He is not dependent on us, we are dependent on him. He is not an interruption in our work, he is the purpose of it. We are not doing him a favor by serving him, he is doing us a favor by giving us the opportunity to serve him. Thank you, Jai Hind.
Thank you, Tarun. And the last participant for this technical session is Sukar.
Thank you for being here, especially on the Festival of Podi, and your precious time. So my name is Sukar Sharma, and I'll be presenting my dissertation. So the topic is Consumer Protection Mediation. The Consumer Protection Mediation Regulations 2020 and its interplay with A, e-commerce, and B, with the bargaining power disparities inherent in mediation. Now, my central thesis throughout this paper is that essentially the mediation process, Regulation 12, which delineates the mediation process under consumer protection. Is it? Yeah, thank you. So I'll just start from the beginning. Thank you all for being here. And So, my name is Sukaran Sharma and my topic is Consumer Protection Mediation Regulations 2020 and its interplay with mediation with the e-commerce entities and B with the bargaining power disparities inherent in mediation. Now, my central thesis throughout is that the Regulation 12 under the Consumer Protection Mediation Regulations needs to be amended to ensure a mediation process which is fairer to consumers and which reduces the bargaining power disparities and alleviates the consumer problems which they face in the current mediation process. And to substantiate this, I'll be using a 4-part analysis. In part 1, I'll discuss the relevance of mediation in e-commerce transactions. In part 2, I'll discuss how mediation currently does exacerbate the existing bargaining power disparities. In part 3, I'll discuss how changing the Regulation 12 can reduce those bargaining power disparities using the risk grade. In part 4, I'll substantiate the same using game theory. Now, coming to part 1, there are 3 broad reasons why mediation is relevant to e-commerce, especially e-commerce over normal transactions. Now, the first reason is that obviously the pecuniary claims in e-commerce are generally lower than we'll see in normal transactions. For example, if we're buying a house, etc., that's still a consumer transaction, but we don't do that during e-commerce, right? We can buy a phone or a laptop cover. These are the sort of things which we buy during our normal e-commerce transactions. So in those cases, it might not be relevant for us to approach the proper consumer fora, and the mediation process might just be easier. The second reason for the same is that there is a problem with jurisdictions. As my friend Siddhant pointed out, that during flash mob sales or even processes where there are a lot of transactions involved, for example, the booking place, the place being booked, and where you have to move around a lot, especially in e-commerce transactions, courts are often confused as to the jurisdictions. Even though the CPA goes a long way in clarifying which jurisdiction, which fora has jurisdiction, there's still confusion in this regard. As you can see in Rajendra Chawla versus Make My Trip, the court essentially had to forego taking that case because of the fact that there was a problem in deciding jurisdiction over the e-commerce transaction. So in these cases, mediation can help solve this problem. Coming to the third reason, which is the online nature of mediation. So online mediation has a very important scope here because in e-commerce transactions, there is a large geographic dispersal. We have entities in different parts. For example, our goods may be shipped from USA, may be transported to Mumbai, and from there it might come to your location. In those cases, it might be difficult for all the parties to assemble at one jurisdiction. And by virtue of the fact that mediation is online, this problem can be resolved. So I basically in part 1 gave you three reasons why mediation is especially germane in online transactions, in e-commerce transactions. Now coming to part 2, the bargaining power disparities in mediation. So essentially we always have bargaining power disparities even in normal court litigation, but they get worsened during mediation often because we don't have the procedural safeguards that we do in normal litigation or in the normal consumer fora process. So, for example, there's almost always there will be a large e-commerce entity against a single consumer because as it is, matters of public interest are not referred to mediation as per AFCON. So we generally have a lone consumer against a large e-commerce entity which can then exercise its bargaining power, its higher bargaining power to get a lower compensation. Now, what we need to keep in mind is that this generally takes place under a very narrow mindset that a lower compensation is in the best interest of the e-commerce entities. But if we take a more long-term view, we'll realize that even for the e-commerce entity, getting a very low compensation might not be the best case. Because when you look at it in terms of goodwill, if say Amazon consistently gives out very low payouts in its mediation proceedings, the mediation settlements, that can lead to a loss of goodwill for Amazon or for any e-commerce entity that we're talking about. And the larger the e-commerce entity, the worse the loss of goodwill will be. So in most cases we'll realize, or the e-commerce entity should realize, that in cases of mediation, it should not exercise a higher bargaining power to get a lower settlement because the loss of goodwill would outweigh any lower compensation that it would have to pay. But how do we get to that? That is what we'll address to part 3 and part 4. Because as I explained earlier, the regulation 12, it does not solve this problem. Why does it not? Because it essentially incentivizes a facilitative mediation over an evaluative mediation. Now, facilitative mediation is very useful in a lot of areas. But when it comes to bargaining power disparities, facilitative mediation is not the best way to go forward in e-commerce transactions. This is because in facilitative mediation, the primary goal is to clear up miscommunications. The primary goal is not to tell the consequences of non-settlement or the consequences of a very low-side settlement. In those cases, the bargaining power issue gets worsened because they don't see the long-run view that I explained, in which even for the e-commerce entity, it would be better to not exercise the high bargaining power. So, to get to that stage, we need to understand that we need an evaluative mediation over a facilitative mediation. Now, coming to part 3 of my paper where I discuss how this can be done. So, Riskin proposed a grid of 4 continues, right? And it includes, first of all, whether the mediation is facilitative or evaluative, and secondly, whether the mediation involves a narrow problem definition or a broad problem definition. And it divides it into 4 quadrants. Now, every quadrant has a specific purpose, right? The quadrant we are interested in the top right quadrant, which deals with broad problem definition and evaluative mediation. Why do we want that in e-commerce? It's basically because in those cases the consequences of a lopsided settlement become clearer, right? If you have a broad problem settlement, we can see the long run consequences. And the importance of evaluative mediation as I've already discussed. In those cases, the firm is more likely to realize that if it forces the consumer to settle at a lower payment, by force I mean exercise its higher bargaining power to get a lower compensation, what will happen is that the firm will lose goodwill. And in this case, the top right quadrant of the Riskin's grid that I've talked about, the firm will realize that it's ultimately facing its own loss by doing that. And that is why I propose that Regulation 12 be changed to emphasize an evaluative mediation with a broad problem definition. Now, coming to part 4 of my paper, which deals with substantiation of the same using game theory. Now, we have 2 important things to keep in mind here. First of all, we are looking at it in ordinal terms, not cardinal terms. Meaning that we're simply looking at where do we have a higher incentive, not in numerical terms. And second thing, we need to understand the difference between a one-off game and a repeated game. A one-off game is where the firm just looks at it from this particular mediation proceeding and it does not consider the future mediation proceeding that it might have to undergo. In a repeated game, it also considers that it will have to probably get into mediation with a lot more consumers in the future. So, in a repeated game, it realizes that there are more consequences if I force them to settle for a lower payoff. Now, so what happens during the rightmost top right quadrant of this thing that I explained when we incentivize a higher as in broader problem definition and an evaluative mediation is that the problem shifts from a one-off game to a repeated game. And when it shifts to a repeated game under mediation, what happens is that the firm realizes that in this case, it would not be in its best interest to exercise the higher bargaining power. So, coming back to finally concluding the entire thesis and the 4 sections, is that we have to realize the Regulation 12 needs to incentivize an evaluative mediation over facilitative mediation and a broad problem definition over a narrow problem definition if it is to reduce the bargaining power disparities that are inherent in mediations of e-commerce entities. Thank you.
Yes, thank you, Sukhar. And this brings us to the end of this technical session on e-commerce and consumer law. We'll now move to the discussion round, and I'd request the participants to come on stage. And we'll take a few questions and discussions and so on. So yeah, while the participants are here on the dais, one common thing that's running through the thread of these 4 presentations is the role of intermediaries, right? In many of the first two presentations, there was a very important discussion on the role of intermediaries in e-commerce. That was a very important takeaway of this discussion. And the next presentation brought us to awareness. So there is something called, out of the 6 rights, we have something called right to consumer education and awareness. We need to bring that distinction. when you talk about consumer education, we now have a lot of schools and colleges who are touching upon consumer education, no doubt. We have a class 6 or class 7 subject which talks about consumer education. But what is the extent of awareness? It is something more than just being educated about it. It is creating awareness in every walk of our life, whether it is goods, services, or whatever we procure. So that's an important element that our students have brought about. And the last concept, the last research paper being on consumer mediation and its impact, how impactful it can be in an e-commerce setup especially, and when it's a face-to-face, non-face-to-face transaction and parties at a distance, and that ODR would be a good tool in terms of resolving disputes. So these are the 4 key takeaways we've had, and we'll now move into the discussion. We have a few questions. Yes, sir, please.
So this question is not specific to e-commerce, generic. It could be applicable to e-commerce as well. See, we are in business, we run business. I want to give it a different perspective from the Consumer Protection Act as opposed to for the Consumer chapter. So I was talking to Dr. Ravishankar as well. See, sustaining a business today, especially MSMEs in India, is very hard. Based on the taxation rules that we have, regulations we have, various other laws are there, right? On top of that, if we get actions on these consumer initiatives, the problem is we need to look at how to address especially the local market manufacturers and the small scale industries. So recently I am on the verge of closing one manufacturing unit just because I cannot address all these things. Whether I am sure and then I have law knowledge myself. So what I need to bring here is this investigation wing is at the central level, right? It's not at the district level or state level. Will it go to the extent of investigating what are the deficiencies in the system of the unit, the manufacturer or the producer? And if it goes, if there are unknown faults which the manufacturer himself is not aware of, how exactly do they investigate? And what are the differences that as a manufacturer or product supplier I'm going to get in such situations? Because I'm on the verge of whether to adhere to all these laws, even though I'm not aware of it, or sustaining my business. When we need this, and my question is like, what is the depth of this investigation wing, especially at the local, district and state?
Yeah, I will take that this. Sir, this one discussed even in the central government discussion also. Always Prime Minister is concentrating whatever you make a law, it should not disturb or affect small business people. So one of the e-commerce rules, it is asking, it is mandatorily you have to register GST number. And GST comes only when above some lakhs amount business. So these road vendors, they cannot, or small shops, they cannot have that particular GST under the Act itself because they are not going up above that particular thing. Then we have suggested, that was discussed, and now we are making, for example, when the Secretary discussed with me on this point, I gave an example. Under Food Safety and Standard Act, road vendors are allowed. And for road vendors, different liberal rule is applied. Now road vendors, no fees is given, only they have to register in the municipality that I am selling in this road. Because ultimately, if any adulterated goods or food is sold, poor or rich, they are held liable. To that extent, identification is mandatory. So in that way, I suggested even under the e-commerce rules also, kindly make this change so that small scale industries should not suffer. And always another thing is, multinational companies are more expert, they are expert, and small companies will die in that competition. So they are looking on those lines also. And yes, in every angle they are looking after. Specifically, they are asking questions and especially under rules they are making. Your point is also correct. The small scale industry should be encouraged, and also in the new proposed bill, new amendment to the e-commerce, Pratima may say that especially these local, the e-commerce companies should be entertained in that. So in that way many things have been changed. So my statement or my view is, yes, whatever amendments are happening, whatever laws they are making, they kept in mind there should not be severance of small scale industries, small business people, and at the same time they are not excused, exempted from whenever they sold adulterated or anything. So they are balancing, but maybe some rules already made, but they are trying to amend those rules. They are working on it.
If I may just add to what Professor has been mentioning, and very rightly, the question that you bring about, we do connect with a lot of MSMEs, rather startups, early nascent stage startups when it comes to e-commerce, who come and ask us, what is it that I should know before I start this business? Or is it too much of a legal compliance? Is it too much of a hassle that I have to, do I have to continuously look at what is the law, or should I focus on my business? That is always the question which businesses would come up with. Now, there is nothing like a straitjacket answer to this. But what we could consider when it comes to MSMEs especially is, of course, whether it's a large company, a small firm, a micro firm, whatever it is, ignorance of law is no excuse. Ultimately, you have to face your consumer. Now, coming to the CCPAs and the authorities here in terms of what is the role that we can play, let's understand, this is for all of us in general, let's understand consumer law is for the consumer, no doubt. But it is something which the businesses also need to understand. Ultimately, it is a B2C. Ultimately, your goods has to reach out to the end consumer. So you, as a business, would have to know what are the basic laws. That is number one. And the second thing being, it is also ideal to explore a little into your industry-specific laws. That is something which should be considered. Now, suppose you are going to start a hotel industry, like one of them did present. So you need to understand FSSAI. You need to understand some basic laws governing what is it that you are going to sell, your products. Or if it's fintech, it's very heavily regulated. You cannot say, no, I want to focus on business first and then let me think about the compliances. So that's where, we sort of need to weigh that balance as a business. And of course, keeping in mind the consumer protection. I don't know if that answers your question. I hope it does.
Yeah, additional to that, under the product liability chapter, now they have clarified when product manufacturer is held liable, 84, 85, when product service provider is held liable, when product seller is held liable, everything is clearly mentioned. And also section 87 gives exception to product liability for sellers, manufacturers. So if you fall under exceptional clause, you are not held liable, but otherwise you are held liable. So that is one. And if you look into the in YouTube, Cabinet Minister Piyush Goyal's speech is there. If you look into that, they are also worried, especially here his speech was on Legal Metrology Act. And first offense, he has brought the statistics. First offense, 81,000 in 2018-19, then 92,000, then 85,000 first offense. Second offense, 11,000, 10,000, 0. So he clearly mentioned harassment is happening for small business people. How we can reduce it? So that is the agenda of this year. Next World Consumerist Day, he wants a solution, he wants to declare. So we are working on that particular. Thank you.
Good afternoon. I am Sneha Kumari from KLE Society Law College. My question is regarding online mediation, as you mentioned. As we know, the time structure of countries are different, then how virtual mediation will work in such cases and how the speedy disposal of cases will prevail in such cases. as we know, the time structure of countries are different, then how virtual mediation will work in such cases and how the speedy disposal of cases will prevail in such cases.
Right, so there are specific online mediation centers which will account for the fact that there are different time zones in different countries. But even if we have, say, a 5-hour time zone, 5-hour time difference, we still have overlapping periods during the normal business hours where they can still engage in mediation. That just requires normal coordination. For example, if we have to mediate with someone in the UK, we can still figure out a time which is, say, like 3 p.m. for us, but like 8 a.m. for them. So it would still work.
See, here in continuation with his answer, so presently mediation, under mediation, the Consumer Protection Act, it is applicable only for Indian people, Indian disputes. So there is no question of the other thing. Yes, if the parties are in other countries, Indian plus, but they are in other countries, see, mediation is a voluntary process. With the consent of both the parties, mediator is fixing the time and date. So there is no question of the problem. So mediator has to discuss with both the parties when is comfortable for you and another person. Both parties are agreeing. At that moment, they fix the mediation. So this is not a mediator's decision. No, on this date, in this time, you should come. No. That is not called as a mediation. Mediation is a voluntary process. Every stage is a voluntary. And at any stage, even though they are coming for mediation, it is not mandatory for the parties to settle the matter through mediation. No. At any stage, they can come out from the mediation if they are not comfortable with the mediation process. If mediator is saying odd time, mid-time, which is he's busy, then he can, the party say that I'm not interested, mediator is not coordinating, he can file a complaint to the even commission against the mediator. And the commission will change the mediator by giving opportunity to him to that what is his opinion. On that basis they will change. So all the facilities are made under the Mediation Act, so that is not a problem.
I direct this question towards you, ma'am. So with the introduction of mediation cells in the 2019 Act, how do you see the situation or the existence of commissions, ma'am? Will it change or will it be the same, the control it has now?
Okay. It's not necessarily, because what we see here, if I'm right, Professor, these are court annexed mediations, right? The matter has come before the court. You need to also understand the different types of mediation. So there's a private mediation where it's just the parties who decide who appoint a private mediator and decide the dispute. This particularly is a commercial, this is particularly a court annexed mediation. Vis-a-vis a commercial dispute which has a pre-institution mediation. Even before the court is, even before the case is brought before the court, they do a pre-institution mediation there. So this is something we need to understand. These commissions, they will never go out of job. They will remain, and there are a lot of cases. This will continue, right? The mediation is only going to supplement, is only going to add to redressal, speedier redressal. What was the purpose of bringing in mediation? As it is, we had these commissions for the purpose of redressing disputes speedily. That was the purpose. Even if you read the 1986 enactment, it said speedy disposal of disputes. Now, because that was not possible, we have introduced another instrument called mediation, which will hopefully supplement this, the existing practice, and hopefully we will have faster settlements. That's how I would look at it.
In continuation, Pratima, see, for mediation, it is a post-litigation mediation under Consumer Protection Act. Mandatorily, the case has to be admitted in the Consumer Commission. And then they ask the parties, are you interested to settle the matter through mediation? If they say yes, then they ask, the Commission asks, give us written consent. Once they give written consent, then only they refer for the mediation, otherwise not. That's the first point. And under the Act, it is said mediation cell attached to the commission. So attached, is it a physical attached or recognition of the mediation center? So presently, no state, even Karnataka, has not come out with the mediation cells. Now they are referring these mediations to district annexed mediation center, district court annexed mediation center. It is not attached physically to the Consumer Commission. So similarly, I discussed with the National Commission President and Secretary. They said it is not a physically attached. Recognition is important. It should be recognized by the Commission. That's first thing. And if let us take an example of online consumer mediation center. So we cannot do immediately without ourselves recognizing in the district commission or state commission or national commission. So our center should be recognized by them, and whosoever mediating in our center should be empaneled in the commission list. Then those people can be referred here. So recently, maybe 6 months back, National Commission advertised whosoever is qualified under particular section can apply for mediator. Even I have applied, and 2 days back I got a letter that you have selected. Kindly give consent for that. So this is the way how it works.
My name is Deepa. I have a question, not necessarily from a consumer perspective, but more from an interpretational perspective. So we see that the e-commerce rules, there is a lot of overlap with various other legislations. One of them happens to be the definition of e-commerce entity itself. So the rules provide that any e-commerce entity is an entity which is regarded as a company under the Companies Act 2013. Alright, so under the Companies Act 2013, it's a very broad umbrella. It also includes within it associated enterprises, JVs and related parties. So now what happens as a result of this, if we are reading all the provisions, then all these related parties or all these associated enterprises which are not necessarily into the e-commerce business, they will also be covered under the ambit of e-commerce rules, and even they will have to maybe follow certain procedures and guidelines. So that is an unnecessary burden on those companies. So what happens in such case? What is the interpretation? And also one more point, another question. With regard to grievance under the e-commerce rules, somebody mentioned that with regard to the hotel industry mentioned that they will have to set up grievance cells. The IT rules also provide for creation of similar grievance cells. So when there is a conflict between the e-commerce rules, when the consumer is approaching, so which rule will take precedence? Will it be the e-commerce rules or will it be the IT rules? What is the interplay there?
This is a question of special law versus general law. One thing is very clear. The Consumer Protection Act is not in derogation to any law that is in accordance. If I'm not wrong, section 103 deals with this particular provisions. Moving ahead, there are a series of cases, the National Seeds case, or the Telecom versus M. Krishnan case. Over here they have said, if there is a law that is dealing with this particular specific field, that law shall supersede the general law, that is the Consumer Protection Act, that is number one. Number two, as far as your question related to the company that is related, if the said company registered under Companies Act is involved in the process of e-commerce, we shall bring them under the ambit of the CPA and they will have to comply with it, because this is a law made for the consumers. And it is made in such a way that it is easy for the consumers to avail remedy, and also one of their consumer rights, that is right to redressal of grievances, is need to be taken into consideration. And moving ahead, a long-standing disputes have been coming across in the conflicts of laws that comes. So adding further to that, in the national seats case, they have clearly said, if there is no specific provision for seeking remedies in the special law, then we shall revert back to the general law in case the general law gives the remedy to the aggrieved party. Therefore, this is the context of the special law and the general law, and I hope your question is answered, ma'am. Do you have any further?
Megha, I understand your question as there is a definition, there is a provision under this Rule 4 which talks about an e-commerce entity shall be, and what is it? It's a company incorporated under the Companies Act. Okay, that is your main concern, where you are looking at the inter-company relationships. So it may be a subsidiary, it may be an associate company. So are all of them going to be tagged into something like this as a dispute? Is that your question? Okay, the first thing. So when we talk about this, first of all, when we talk about associate companies, subsidiary, you can very well work around that, because usually what happens is, when it comes to the litigation also, when it comes to a consumer case before the court, right, before the consumer forums, they come up with, let us say, Amazon so-and-so, and then they say Amazon seller so-and-so, and then they come up with 2 or 3 or 4 related names. And ultimately, the company internally decides as to who is going to take this matter, okay, onto themselves. When it comes to associate companies also, it can be an inter-corporate relation as to who is going to take up disputes of this sort. Now suppose Tata and Starbucks. So who is going to take up disputes, of this nature? They may have an inter-corporate relation in this aspect as well. But my major concern on this particular provision is, if we say an e-commerce company shall be only company and as under the Companies Act, then what about partnerships? There are a lot of startups today who are just registered as partnerships or under any other form of business entity. It may be a sole proprietorship also. So all of them are removed from this ambit. That's my concern. That's how I would look at it, rather. Okay, and what was your later part of the question?
Grievance mechanism is one of the examples.
Right.
So your